Hello and welcome. My name is Alan, and today we are doing the first of our video series I will be doing on the Supreme Court. Since we are also doing videos on Congress, I figured let's do a series on the Supreme Court, and of course I will do one on the executive branch, being that the American government is separated into these three branches of power: legislative, executive, and judicial. But in this one, we will do the first episode about the Supreme Court. Um, it is considered the highest body of law in the United States, the highest court. And supersedes the decision of any other court. And because it has such an important role and can have such a huge impact, the actual court has the option to decide which cases it will hear. So just because you may decide the court may be constantly appealed up to the Supreme Court, doesn't mean it will be accepted. So, yeah. And it does play a role in balancing the powers of the nation. The legislative branch, which is the two houses of Congress, the House of Representatives and the Senate, make laws and, decide a lot of the laws that are created for the U.S. to follow. The executive is meant to be someone who signs off on these laws and does what he can to enforce them. He's also the head of state, as he is an elected representative of the country. And then, of course, the Supreme Court, the judicial branch of the separation of powers, it balances out the Congress and the president by deciding, okay, if your law or your executive act is brought before us, we can decide if it's in violation of the Constitution. And so, yeah. And the first instance we see of this, which is what is called judicial review, is with the case Marbury versus Madison in 1803. So very early in the country's history. Now, let's jump back a bit in history here. Before America struck out for independence, it was under the British Crown and British Parliament. And it followed many of the same laws Well, it followed all the laws passed by Parliament. Although Parliament, for its part, really didn't do much in regards to rules in the U.S. Before 1690, there was only like, I believe it was around 100 laws that Parliament even passed that dealt with issues in the colonies. So for the most part, they were more just a place to gain wealth and riches than really a part of Britain itself. But with this fact, much of the all of the colonies followed many of the same rules that the British courts used. In fact, they adopted the idea of common law. And it was the basic idea. The laws would vary from colony to colony. Pennsylvania had different judicial rules and laws than North Carolina. They would vary somewhat. There was generally many of the same ideas, but there would be a bit of variance in them. But for the most part, they all did follow the idea of common law. Now, with independence in, well, with the Declaration of Independence in 1776, they needed a new guiding document to say, this is what we follow, this is what we believe. And so their ideas for a government were set down in what's called the actual Articles of Confederation. And this was adopted on November the 15th, 1777, by the young country. We weren't yet free from Britain, but we were saying this is what we should now follow as our law. Now, while it did make all the colonies as one country, it did a lot to make sure that the colonies themselves had a lot more power over what went on than the country as a whole. Now, these Articles of Confederation basically said that most cases were to be decided in the states that the law broken was in. Only as a issue of last resort, and in cases where it was a dispute between the states or the colonies themselves, a federal court would decide. But for the most part, they did what they could to maintain that the state courts had the main decision over deciding on laws, which it's something we know very well with the Articles of Confederation, that they were very lax um, on the colonies. It focused more on their rights than the country holding together, which, as I said, the Articles of Confederation, written in November the 15th, 1777, they were adopted um, by the 13 colonies, which became the 13 states, finally on March the 1st, 1781. But there was a problem with the Articles of Confederation because the central government had no real power. It caused a lot of issues. And so they had to call a constitutional convention in 1787. Because they were having severe issues with paying soldiers, and a number of other items, because often where the colonies had so much right over what they could do, they had different currency many times and different value for many items different times based on what the colony decided. And so there was no set central regulation. So they had a new constitutional convention in 1787, and so a new document was written called the U.S. Constitution to replace the Articles of Confederation. And it was adopted on March the 4th, 1789. Now, in this Constitution is where we see a development of a Supreme Court. Because in 1789, there is what's known as the Judiciary Act of 1789, officially titled An Act to Establish the Judicial Courts of the United States, and was signed into law by President George Washington on September the 24th, 1789. So literally a few months after the Constitution came into being. Article 3 of the Constitution established a Supreme Court, but left to Congress the authority to create lower federal courts as needed. The act itself was principally authored by Senator Oliver Ellsworth of Connecticut and established the structure and jurisdiction of the federal court system and created the position of Attorney General. it would be amended throughout the years by Congress. But the basic outline of the federal court system established by the first Congress largely remains intact up through today. So, with Article 3 of the Constitution and the Judiciary Act of 1789, we see the Supreme Court as being the highest court in the young fledgling nation. So, yeah. Now, give me a moment here. I'm kind of going through all the little things I have bookmarked. The Supreme Court itself, it has, as far as the Article 3, Section 2 of the Constitution, it establishes the jurisdiction or the legal ability to hear a case of the Supreme Court. The court has original jurisdiction. A case is tried before the court over certain cases. In other words, suits between two or more states, and or cases involving ambassadors and other public ministers. So not only is it the highest court to appeal to for any cases, it also decides cases where two states are in dispute, two or more states are in dispute, and any cases involving ambassadors and public ministers. The court has an appellate jurisdiction. The court can hear the case on appeal on almost any other case. So as we was talking about, the highest court to appeal to, that involves a point of constitutional and or federal law. So yes. Yeah. When exercising its appellate jurisdiction, the court, with a few exceptions, does not have to hear a case. The Certiorari Act of 1925 gives the court the discretion to decide whether or not to do so. So like I was mentioning before, just because you get an appeal up to the Supreme Court does not mean the Supreme Court has to listen to it. In all, the Supreme Court agrees to hear about 100 to 150 of the more than 7,000 cases that it is asked to review each year. So yeah. Now, the justices, right now there are 9, I believe. Which the number has varied slightly over time. It says here, over the years, various acts of Congress have altered the number of seats on the Supreme Court from a low of 5 to a high of 10. So it has been one higher than the current 9. Shortly after the Civil War, the number of seats on the court was fixed at 9, which is what it sets at today. And there is one Chief Justice and 8 Associate Justices of the U.S. Supreme Court. And like all federal judges, justices are appointed by the President and are confirmed by the Senate, which Donald Trump, even though he was a one-term president, was able to get 3 justices put on the Supreme Court. Despite the fact that the Senate during Obama blocked Merrick Garland for almost a year. But anyway, they typically hold office for life, which is something I think needs to be changed. The salaries of the justices cannot be decreased during their term of office. It can only be increased if it's agreed upon. These restrictions are meant to protect the independence of the judiciary from the other political branches of government. So, in other words, anytime they do something, they can't be influenced or punished by another branch for doing what they do. So Congress sets laws, creates laws. The president can either sign off or refuse to sign a law. I think he has the power to veto. He also has the power to make certain executive actions. And the Supreme Court basically decides if Congress's laws and then the Supreme and the President's actions line up with the Constitution. So, yeah. And that's kind of a basic idea of what the Supreme Court does, how it functions. But yeah, in the next few videos on the Supreme Court, we will be talking about the justices. When they served, what are the major cases they took part in, and we'll even list who the Chief Justice of a court for a certain period was, under what presidents they served as well. So I will have links for the information in the description below the video, but that will be all for now. As always, educate thyself, think, read, study, learn. Someone tries to tell you something you have trouble believing, ask them to cite their sources. But I'll see you all in the next video. Until then, later.